Wanted to share here just a few tips on what happens involving disputes or litigation over non-probate assets or non-probate transfers. These are assets that pass outside of probate. Hi, I'm Kent Berk. I'm the founding and managing partner here at Berk Law Group in Scottsdale, Arizona, where we specialize in probate, trust, estate, inheritance, and other related property disputes here in Arizona. One of the common types of disputes that we deal with is disputes over assets that pass outside of probate. Like I said, non-probate assets. Some examples of non-probate assets would be real estate that's held as joint tenancy with right of survivorship. That could be community property with right of survivorship, or just simple joint tenancy with right of survivorship. Bank accounts that are held with more than one person by default in Arizona law are joint tenancy with right of survivorship, so it automatically passes to the survivor as each co-owner passes away. And there's many other types of non-probate transfers that are listed on our website, such as transfer on death designations. These types of assets or transfers, designations, can be challenged basically for all the same reasons that a will or a trust could be challenged, such as lack of mental capacity, someone who is of unsound mind, or undue influence, fraud, sometimes in rare circumstances, a circumstance of mistake where someone thinks they're adding someone, let's say, to an account just to facilitate them paying bills. And then, as it turns out, they didn't check the box to opt out of the default rule of joint tenancy, and the other co-owner survivor who was just added for convenience could end up inheriting that account under basically false pretenses or a mistake. So those are just some of the examples of the types of disputes that can arise involving non-probate transfers. Now, one really closely related issue involving non-probate transfers is claims for financial exploitation of vulnerable adults. Sometimes you'll have, let's say, a joint owner added to a bank account, and the co-owner who's added, let's say, for convenience, like a caregiver or a child who's paying mom and dad's bills, starts using that money for their own benefit and not for the benefit of their parent or their client or whoever. And in Arizona, it recognizes a claim for what's called financial exploitation of a vulnerable adult under Arizona's Adult Protective Services Act. And there are just three quick elements. And if you have a person who's acting in a fiduciary capacity, a position of trust and confidence to a vulnerable adult, that fiduciary has to use the assets solely for the benefit of the vulnerable adult. And if they don't, then they could have severe liability. We have many other videos and articles about that, so I won't get into the details here. But those are just some of the examples of situations and claims and disputes that can arise over non-probate transfers and non-probate assets. If you have any questions and you need any help in a dispute over a non-probate asset or a will or a trust, estate, or inheritance, we're here to help, and just don't hesitate to reach out to us. Thank you.